Hi, I am Jeffrey Wernick, and welcome to BitChute. And I guess maybe it's kind of ironic that this BitChute is with uh, the person who previously hosted BitChute, Amy Peikoff. Uh, Amy, I'm happy to have this conversation with you. I'd like to give everyone a little bit of background on how I got to know Amy. Um, I am someone who I'm a very not only am I a strong advocate of free speech absolutism, but also a privacy absolutist. For about the first 100 years of a country's history, really the government had no uh, the government collected basically no personally identifiable information because there was not an income tax. So there was very little that people had to
Mhm.
submit to government where they had to reveal information about themselves. So the people paid tariffs and mostly were funded by tariffs. Government was very small. Government spending was a very insignificant percentage of GDP. We didn't have an administrative state. We didn't have a regulatory state. So really, the federal government really had almost no personally identifiable information on anyone. So, it was it was appreciation for a society that valued privacy, since as basically as Justice Louis Brandeis had expressed it so succinctly and so well, is that basically the most fundamental right of every person is the right to be left alone. So so I basically, on a personal basis, I live my life basically thinking that the only people who are entitled, if anyone wants to know anything about me, they should ask me and no one else. Uh,
Mhm.
and I'll choose to either answer them or ignore their question, and that's my choice. So, but I firmly believe that nobody should be able to get any information about me from third parties, that they should not be able to get information, anything that I don't want to share with anyone else, they should not get with a third party, or I'm sharing with a third party explicitly for that relationship with the third party,
Mhm.
where the data should not be used outside the context of that relationship. So Amy had written a piece on what's called the third party doctrine. I read the journal article. I contacted her, and she, at that point in time when I had read about Amy, is that she was working on a book that I hope she's still working on, called Legalizing Privacy, and I was very interested in her work, and hopefully to see a finished product in the book on legalizing privacy. And so, of the people who I've met, and again, that maybe might be a limited universe of people, but I haven't met anyone with a devotion to really protecting people's privacy, more so than Amy. And I had an opportunity of working with Amy, both at Parler and in BitChute, and she still does advisory work for BitChute. And Amy has been our go-to person on how we can operate a platform. And given all the rules government imposes upon us, with all those rules and regulations that we're subject to, how can we still do the best job of protecting people's privacy? Subject to what the law requires us to know. And basically, I don't like any law that requires me to know anything I don't want to know. And I wish that was the world today, is that if the government wants to know something, they should not be able to recruit third parties to get information from them. And the people are using third parties,
Mhm.
out of a context. Those third parties essentially become spies, okay, on behalf of the government. So that's what they're doing. They're engaging in business with you, and they're also spying on behalf of the government, because they're sharing the information with the government, and they're sharing the information with the government without a warrant or without a subpoena, without any real due process, without any probable cause. They're just collecting this information, and you can be sure it's not going to be used for our benefit. It's going to be used so that they can surveil us, so they can control us. And matter of fact, some of the people who have welcomed in this incoming Trump administration from Silicon Valley have celebrated what they call as these public sector, private sector partnerships, and they're basically surveillance partnerships. And they're surveillance partnerships to control the people. I mean, some of them explicitly said that that's their intention, is to control people. So, as usual, I give long introductions. Hopefully, you think it's a fair introduction. So, I'll turn the conversation over to you now.
Well, thanks for having me on, Jeffrey. When we talked about doing this show, the idea was to make people aware of the numerous ways in which government is doing what I would call using Orwell's 1984 as an instruction manual. And I came armed with a few things that we've been interested in. Now I'm working for Pacific Legal Foundation. And in my work, I'm focusing specifically on Fourth Amendment violations of people's rights as recognized and protected by the Fourth Amendment to the United States Constitution. And I have sort of four main categories that we could talk about. We could probably do it for hours. We've got about an hour here today. But one of them is, I think what you were alluding to, is this effort by the Trump administration, due to an executive order signed by Trump, to consolidate this personally identifiable information that you were talking about earlier from the various government agencies that they collect these days. You and I would say it's probably beyond what a proper government, or actually you believe in no government, but I definitely believe it's beyond what a proper government should be collecting. And what the executive order tells these agencies to do is to go ahead and contribute this information to some vast database, which I guess the company Palantir is now helping to consolidate and make. So that's one. There are a couple things that FinCEN, a government agency that is subsidiary to the Treasury Department, a couple rules that they have promulgated, one that was already in effect but is currently subject to a temporary restraining order, and then another that is due to go into effect later this year. The one said that any transaction in excess of a certain dollar amount in areas of certain zip codes near the border, California and Texas, a lot of these zip codes were there, as you can imagine, any transaction has to be reported to this regulatory agency, because they're going to stop, I don't know, drugs or terrorism, or who knows what they say that they're going to stop. What do you think that dollar amount is, Jeffrey?
$1.
It's getting there, right? Almost. $200 is worth $1 as of what previous year? It's $200.
Yes, it's ridiculous. As the government always does, they claim this nice objective, but then when you take a look at what really they need to collect to accomplish that objective, they're collecting way beyond what they need, beyond the scope of what that activity is. So they're using it as a pretext to just get everything they can. So the number has to be small enough so it captures almost everything, but not so small where it's perceived as being, stupid, like my suggestion of $1. That clear is not meant to target who they say they're targeted, but maybe if they throw $200 out, people might believe that that's the real objective of it. But we know that that's not the real objective of it. It's a pretext.
No. Yeah. I have a friend who has a business in one of these border zip codes. And he said, oh my gosh, 200 barely buys you groceries for a week or something like that, And so what if somebody pays $200 cash at a border, I think it's even just a $200 transaction in any way, how is that even possible? Is it that there's any kind of reasonable suspicion about these transactions? As I said, that rule is currently under a temporary restraining order. It's not in effect. There's another rule that's slated to go into effect later this year. And at Pacific Legal Foundation, we have a case actually challenging the constitutionality of that rule. And what it would do is it would require title companies, property title companies that help to facilitate transactions, the sale of property, other facilitators as well are covered by this rule. It would require them to report to FinCEN the people who are on the buying and selling side whenever there is a non-financed transaction. So imagine that you're buying a piece of property and you happen to have enough money so that you don't have to have a mortgage on the transaction. If it's not financed, and if the parties on either side are a trust of some kind, then according to our federal government, that transaction is inherently suspicious and you have to report it to FinCEN. And, as you and I know, there are a lot of people who are very privacy minded, who have perfectly valid reasons to want to use a trust for purposes of holding title to property. It's too easy to find, somebody's home address out on the internet and such these days, and a lot of people don't want that. And similarly, there's property that's relatively cheap, and there's a lot of reasons that people might have enough liquid assets in order to purchase property that themselves are not suspicious as well. So this rule, we think, is suffering in terms of violating the Fourth Amendment, in addition to other theories having to do with the government exceeding its authority, even under today's statutes, which grant, a relatively broad scope of authority. So that's another example. So we got the database, we have those FinCEN
No,
rules.
this address I want to address. Clearly,
Yeah.
I can understand how the government thinks that anyone who wants to avoid debt in their life must be a suspicious character.
Sure.
So, see, the American way is being a debt slave. Okay,
Yes.
it's not owning assets and being debt free. It's owning almost nothing and accumulating a lot of debt. That seems to be the American way. So obviously, if you're a saver and not a borrower, you're clearly a suspicious character. And because Americans don't do that, they don't save, they borrow and spend. So as the government practices is borrowing and spending. So given the fact that the American way is borrow and spend and don't save, is to go out looking over the world for people who do save and having them buy out debt. And to the extent that we can't find other savers to buy out debt, that we then have the Fed buy up the debt that foreigners are not willing to buy up, because we have no savings to buy up the debt ourselves, because we're in debt ourselves. So clearly you're a suspicious character if you believe in the advice given by our founding fathers, which is, or even back to the biblical times where it says, don't go into debt. So, save for the future, defer current consumption for future consumption, or the ability to enjoy a retirement, in a reasonable lifestyle. So, so apparently, if you believe that you should be prudent by not accumulating debt, by saving, then clearly, you're a very suspicious character. So
Yep.
if you don't want to borrow from mortgage from a bank, you must be a very suspicious character. If you don't want relationships with the banks, and of course, because the banks are one of the main sources that the government gets information from. And so, of course, the government wants to encourage everyone to do business with a bank, so the banks can even though the banks might cancel your account or do other things if they think your activity is somewhat suspicious as well. So, and we supposedly learn, as someone who's a Bitcoiner, you grow up, with the saying possession is 9/10 of the law, which basically, if you apply that, anything of value to you, you should self-custody. And so given the fact that anything's of value to me, I want to self-custody. I don't want to custody with third parties. So apparently, if you believe in that principle of anything that is valuable to you, you want to maintain possession of, apparently there's something suspicious about that as well. So, so
Yeah, no
as
doubt.
you and I know, that's all bullshit. Okay.
Definitely. And, they should have a warrant in order to search whatever you are currently taking self-custody of. And it's,
And there's that probable cause.
probable cause, particularized suspicion behind that
Yes.
warrant. Yeah. So that raises the other two examples that I have. One of them is this ongoing case that we're hoping the Supreme Court is going to grant certiorari for, and that's Harper versus Falkender. It's now called Harper versus Falkender. It started with Harper versus Werfel, but they keep changing whoever the current head of the IRS is. It's currently Falkender. I don't know, it's like hot potato or musical chairs. I don't know which metaphor you want to use for the head of the IRS, but they've been switching it frequently. But in that case, the IRS issued a very broad, insanely broad subpoena to Coinbase, which is one of these third-party custodians of cryptocurrency. And at first, the IRS was seeking all the data on all the United States customers of Coinbase, regardless of how much they were holding or transacting or anything. And Coinbase, to its credit, fought this subpoena, but they fought it down to the point where it affected over 14,000 of their customers. And it was, above a certain trading amount per year. I think it was 20,000, et cetera. And eventually they did go ahead and turn the data over to the IRS. But as to these customers, there was no probable cause or particularized suspicion. It's just what I would like to call the primacy of taxation, the idea that the government thinks it better get, its taxes above all. But
Now, let me ask you a question. Is the government
sure.
requesting the same information from every brokerage, from which was Charles Schwab and TD Trade or whatever, all these other companies? Was every company involved in the business of transacting in securities or commodities, in doing capital markets transactions where people would have engaged in speculative trading activity? Was every company in that business subject to the same order by the government?
That's a good question. And I don't know the particular answer to that. And I hadn't seen that, for instance, I read recently, the Supreme Court ordered the government to reply to Harper's petition, Harper petitioned to the Supreme Court for certiorari. And it's a good sign that the Supreme Court ordered the government to reply. At first they had waived, they thought, oh, nobody's going to ever be interested in this case or whatever. In their reply, I don't remember them saying that in particular. They were just talking about the broad powers that the IRS has in order to make sure that they're getting their due, getting their share of what you have produced, the wealth that you have created. IRS believes it's entitled to its fair share and that they should have almost, a virtual exception to the Fourth Amendment in order to get the data that they need to enforce that rule. But
So,
that
so
case,
the IRS is basically above the law. It's above the law because maybe they get access to data that they should be required to Fourth Amendment criteria for getting that information, and also because when you go to tax court with the IRS, the presumption is guilt, and you have to prove your innocence under which is different than our civil and criminal code. So with our tax code, that seems to be, the IRS seems to be an anti-constitutional. I don't know how the courts have preserved, the constitutionality of the IRS, because I don't know if a court is allowed to say that a government can create an entity where people are deemed guilty and have to prove their innocence. It seems to me that and I don't know if the government has the right to create an administrative body that can violate the Fourth Amendment.
but
So the
that's
question
precisely what's at
the body,
issue here. Yeah.
is the whole issue is that the IRS might be unconstitutional in and of itself because it operates not subject to the constitutional principles, that are supposed to be sacred and that the government cannot violate, and the government cannot create another entity that can violate those rights. So maybe would make for a good challenge of the constitutionality of the IRS. Maybe these have already been challenged and lost, and if they've been lost, they've probably been lost by the court for a bad reason. So
Yeah, I mean, we're going to see what happens with this one, but like I said, I do think it's a good sign that the court ordered the government to reply. The government, in its reply, was definitely pushing the idea that the necessity for the IRS to get its due from our productive American citizens is an excuse to bend or break the rules that have been enforced under the Fourth Amendment. So I definitely want to see it. We at Pacific Legal Foundation, in fact, I was the co-author of an amicus brief in this case supporting James Harper's petition, along with my colleague Mark Miller. And we used in there, of course, the theory of the third party doctrine that you're familiar with, that I've written up before. So I'm eager to see. We're in an era where Justice Thomas explicitly recently has expressed a desire to look at a lot of these judge-made doctrines like the third party doctrine and either revise or eliminate them. They just did this in a case called Ames, a Supreme Court opinion that they released recently. So I am heartened that we're going to be able to do something in that case. And then the final thing I was going to tell you, another example of government using Orwell's 1984 as an instruction manual, is the searches of digital devices, your cell phones, your computers, even sometimes if you're carrying, disks that are storing digital data at the border. They are using the border exception as a pretext to search all of this stuff without a warrant, sometimes with no cause whatsoever. And in many cases, with no cause whatsoever, they can conduct searches of your digital devices, your electronic devices at the border. And those are extremely invasive searches, particularly, I think on our computers, it's a close second, but with the cell phones, the Supreme Court has already recognized in the Riley case that the information that we have on our cell phones, if the government obtained that, they would obtain more information about you than if they had done a really, thorough search of your home, right? There's so much information about us on these devices. And right now at the border, as the law stands, with zero suspicion at all, just because you're coming across the border, they can look through your cell phone using its operating system. A person can go through it. No suspicion at all. And if they're going to attach a device, some sort of forensic device to analyze the data, to even download and copy the data from your cell phone, all they need is reasonable suspicion. And it's reasonable suspicion, of a crime, but it could also be reasonable suspicion of some sort of interest of the US being violated. There's a vaguely worded standard there as part of their rules that would allow them to just take all of the data off of your computer, off of your cell phone with reasonable suspicion, which is much lower than the probable cause standard of the warrant requirement.
What could you do? I take a polite, let's think about the example that you just gave about like in an airport. And an airport is like the border, right? When you're going in, that's the border. When you're going through and being going through the process of showing your passport and visa, whatever, you're basically at the border, and determining whether you get allowed into the country, which means you get to pass. So let's look at the process. You make a flight reservation, okay? Whatever flight information you made, you're giving information regarding passport, and you're giving personally identifiable information at the time you make a flight reservation, okay?
Mm-hmm.
All that flight information is being shared with the government. Okay?
Mm-hmm.
So the government already knows before you get on the plane that you're coming, okay?
Yeah.
And they can vet you at that point in time. They must have these models of vetting the people to see, whether they have any criminal charges outstanding or anything like that. Okay. So they've probably already done some preliminary vetting before you've boarded the plane. They know who you are. They know you're coming. They know something about your past, whether you show up on any database of having done anything wrong.
Mm-hmm.
Okay. So you come across, you get in front of a desk and you smile and you give them your information. What could give them reasonable cause to ask for anything more than that?
Well, recently there was a TikToker, and I've actually got to look up something really quick to give you her name. Let me take a peek over here. Oh gosh, let me see. I'm sorry. I'm going to have to take a peek at what okay. Okay, there. I can navigate through software. I really can. Okay. The TikToker is named Sav. doesn't share her last name, US citizen, stopped at the border in Florida. And apparently in the, kind of scanning through the operating system and everything of her phone, they had decided that it was worthwhile to take her into another room and ask her a whole series of questions, etc. I'm not aware that they actually completely downloaded her entire device, but they did detain her for some time. As I understand it, at the border, you can be detained for a limited period of time with no suspicion. You can be detained for a full day on only reasonable suspicion. That was done to some people that they had reasonable suspicion that they were, for instance, carrying drugs in balloons in their body. You know how people used to do this. I don't know if they still do this. I used to hear about cases like that. But they can detain you for over 24 hours at an airport.
What would cause them to have
Without,
suspicions? If you have no criminal record and you're coming across, what do they look at you and say, you look like the type of person that probably has you have balloons of
I doubt it would just
is
be
that
that. I think that they would have to have some other evidence, so they would have, for example, some other corroborating evidence that you had something in particular on your digital devices, or in the case of this woman that I read the case about, was, she had these balloons in her body. I think she ended up having 88 balloons full of drugs in her body, which I just have a hard time imagining. But, you would think that if they have this other evidence, that they could go ahead and just get a warrant with a judge and detain the person in, using proper procedure. But law enforcement, in my opinion, has become quite lazy
yeah,
because they have benefited from these rules like the border exception, et cetera. So, in terms of, you would have to, you'd have to.
that's exactly the point I'm trying to make, Amy. The point
Yeah.
I'm trying to make right now is, given the information they already have before somebody gets on the plane,
Yeah.
they have time to go to a judge and say, this person's coming into the United States. We want to do an inspection. We want to go to the phones. We want to look at this stuff. Here's what we have. Give us a warrant. Okay. They have
Yeah.
the time to do that. Okay. So that's
Well,
why.
and this is the outrageous thing too,
That's why
Jeffrey.
I
It's
asked the
not
question,
just.
if they have it, let me finish.
Gosh,
That's why I asked the question is, what has somebody done when they get up and give the passport that at that moment has given them probable cause, or any reasonable cause, or any cause whatsoever to do anything more than just take their photo and stamp their passport?
No, they already have other information about them that they're
So again,
integrating.
that's like a point. If they have the information, why don't they get the warrant?
Yes, and that is a really good question. And in the cases that I've read, it seems okay. Well, they could have gotten the warrant, and they just didn't because they have this border exception that they're relying upon, almost in this knee-jerk way. But to be clear, it's not just if you're coming in. So there are cases in which they knew you were leaving the country, and just because it's that you're about to cross a border, and so they'll use it as a pretext. There was a case where there's a border crossing in Houston because the guy was about to leave and fly someplace else, and they went ahead and stopped him and searched everything. No warrant at all. And what level of suspicion? It was never really adjudicated what they had, but they did have information, reason to believe that he had, in his case, child sexual abuse materials on some discs in his luggage. It seems clear that they could have gotten a warrant in that case, and they just didn't do it. The thing that is sad, and I'm learning
So
this in some of
why are
these.
the courts rewarding law enforcement
That's exactly
from violating our constitutional protection?
this is
Since the role of the
exactly.
court
Yeah.
is to protect our constitutional rights. That's
Yes.
the role of
Yes.
the court. The role of the
Yes.
court, that we had a system of checks and balances to protect us, not to
Yeah.
protect government from us, but to protect us from government. Okay.
Yeah.
That's why this Bill of Rights was put in place. It was put in place specifically not to empower government, but to protect us from government. So why are the
Yes.
courts not doing their job?
Well, I'll tell you one way in which the courts are avoiding doing their job, and it's turning out to be just a bounty for law enforcement, not intended pun there. But what happens is there's a suit like this, And even in a case when a judge decides, and there are some judges who are starting to push back on these digital searches and the border, the so-called border exception, even when they do decide that this is unconstitutional, that there should be a warrant, or, in some cases, maybe just a higher level of suspicion, they will allow the conviction, they'll allow the evidence to come in on something called the good faith exception. And so the idea is that the police officer, or in this case, it's always, in order to take advantage of the border exception, it has to be a CBP officer, somebody from the Customs and Border. But those people are themselves in reasonable belief that their conduct is constitutional. That's what the good faith exception is. They have a good faith belief that what they're doing is constitutional, and so the court lets it pass.
There's a problem with their training. They're obviously bad faith, and they're obviously trained how to arbitrage the law, okay, which is bad faith. So I don't see it as, if they were in good faith, if they had good faith, they would then respect people's rights to privacy. And if they had a suspicion and they have the time and they have the opportunity to get a warrant, okay, they would do that if they had good faith. The fact that they're not doing that is already demonstration of their bad faith, not good faith. So if they're being accused, if they could provide indications of circumstances where they didn't have the time or opportunity to obtain a warrant, okay, that I could understand. But clearly, if somebody's leaving the country and they know they're leaving the country and they're not taking an action to arrest the person prior to leaving the country, but they're waiting to them to get to this basically constitution-free zone and then exploiting that, that's bad faith, okay? The judges are not that stupid, okay? So if they're writing this, I don't believe they believe their own words. I think they're liars. I think they're liars who want to give power to the government, okay? And they're coming up with clever words that make them sound like reasonable people. And many of these people claim to be public meaning originalists. Where did James Madison say that the border is free of that you could violate the Constitution around the border? Where did James Madison? Was that in the Federalist Papers? I don't remember reading it in the Federalist Papers.
Right. So this is the thing, though, right?
That basically the border becomes a constitution-free zone.
No,
Where is the text in the Constitution supporting that, Doctor?
So what they're doing, Jeffrey, is they're saying, look, these digital devices are just another type of property, and there's been a long-standing recognition that you could just search property at the border, because with property you're trying to avoid people bringing in stuff that would be subject to customs duties, that would be contraband of various kinds. Today they're looking for fentanyl and other things that could cause harm to US citizens. So there are, and then of course immigration violations at the border, right? That's the third sort of traditional need to conduct these warrantless searches at the border. And
I don't understand any of those. People are submitting their information. They should not be allowed to board a plane if there's any question about whether they have the right to fly into the country. We already have that ban information, and they should be banned. The government should signal to the airline to cancel this, not have people board a plane and get picked up, when they get here, knowing that,
right. But so what you're doing though
is reasonable. None of it is.
But so what you're doing though is you're talking about the context that exists today with respect to the information that's already in the possession of the Border Patrol people when people arrive at these ports of entry. But at the time that this precedent was established, there was not that information. And so you would just be able to look at whatever the person was carrying with them and look at the person themselves. And they wanted, relatively broad authority, because at the border, you've got this power to make sure that the people who are coming in are not invading or going to harm, or et cetera. Now, with respect to good faith, okay, in the jurisdictions where the good faith, let me try to clear. You're saying a lot of things, and I'm going to lose track of
go ahead.
Information that I need to give you to answer. So, So with respect to the good faith exception, it is applied in a good and honest way by a judge whenever the law of a particular jurisdiction that they have, power for, adjudicative powers for, whenever that law says that or arguably says that the conduct that the officer engaged in is legal. And there are some very valid disputes right now because the law in this area is so new. Most jurisdictions, actually, with respect to digital devices, just say, oh, it's nothing different than any traditional property, and we're just going to apply the usual rules that have been there for decades and decades. There are a few jurisdictions, like I said, where a judge has said, okay, this is unconstitutional, but in this particular case, we're going to allow the conviction to stand. We're allowing the evidence to come in because the officer who got the information was acting in good faith, given the state of the law at the time that he was doing this. I mean, the rules that Border Protection are giving these people are that they're able to do this. Now, what you would assume then is once a ruling like this comes down, then they're going to change their behavior within the particular jurisdiction that the ruling applies to. And right now, we actually do have circuit splits in the United States, where in some places there are certain type of searches that can be conducted without a warrant, and in other places, no. I'll give you another example. In the Fifth Circuit, there was this case called Smith, and Jamar Smith was actually the defendant, and it was a geofence warrant case. And the Fifth Circuit decided that these geofence warrants that Google would get, where they'd say, okay, Google, we want to know how many Google devices were in a particular zone around the scene of a crime within a particular time frame, et cetera. And those do not have probable cause or particularized suspicion with respect to any particular owner of a Google device within that area, et cetera. And the Fifth Circuit struck those down, but then upheld it under the good faith exception. So the only appeal that was possible for this person to the Supreme Court, Smith, was to appeal on grounds of the good faith exception.
Well, the
And
good faith exception sounds to me like tie goes to the government. Okay, so
it is. But then what the hope is that after that one case goes by, and then a court either, for a jurisdiction like the Fifth Circuit, or hopefully the Supreme Court takes it up and, could decide something that applies more broadly about geofence warrants. There's a different case that is better positioned procedurally for that to happen, for the Supreme Court to actually rule on the constitutionality of geofence warrants. Once that happens, then no law enforcement officer acting within that jurisdiction could be acting on good faith if they're using just a geofence warrant as the pretext for being able to get your data. There's a lot of movement in this area. And so I do not buy the idea that all the judges that are allowing good faith exceptions to happen are acting in bad faith or anything else. I just think the law in this area is a mess and really needs to get cleaned up. And so I'm really glad to be working for Pacific Legal, where we're working on doing that kind of thing.
Well, I listened carefully to your explanation. I don't think any of the judges are acting in good faith that ruled this way. And again, I understand your explanation and why in the past giving people at the border this type of discretion was necessary, but that was in the past. Okay, the current circumstances don't justify them having that level of discretion. Everyone getting on a plane, they can go through every database throughout the globe, okay? Throughout the globe, they can call Interpol, the Five Eyes, okay? We have so much surveillance technology out there, okay, that the government has enough time for everybody that when they get a reservation to immediately search every global database in the world that every day is populated with even more information, okay, to determine whether this person is a risk or not a risk.
No, I get your point. I get, but I have two
People
questions
shouldn't be coming across the border and then being asked even more questions. Okay, I don't know what would give them probable cause. That the time they get to the border to basically have people, because they know these people getting on the planes have not been implicated in any criminal activity whatsoever by the thousands of databases and thousands and millions of data points they have that they already have access to, okay, before the person even gets on the plane.
Well, I have two questions for you. One is, yes, as a matter of fact, there is a whole bunch of information that they already have, such that you would think even the traditional search of property and detaining people and stuff at the border, that shouldn't be allowed. But should they even have all that data, or has all of that just been enabled by the third party doctrine that's here in the United States and similar legal climate in other countries of the Five Eyes, et cetera, right?
They should have that data to begin with, is what I would argue, that they shouldn't have that data. Okay.
Yeah. So if they shouldn't have that
given the fact that they have that data, and with all that data, they don't even think that's sufficient. Okay. Because that's the statement. Okay?
No, it is outrageous. I agree.
Even all that data that they have collected, aggregating, that they're trying to get even more, okay, against our will, without probable cause. Okay. That's not sufficient for them.
So then that would be an interesting type of challenge to say that in today's age, upholding even the traditional border search exception is not something that's viable because it's not necessary given the amount of data that they already have. I don't know that I would want to make that argument though, right? Because, here, just thinking off the cuff, I hadn't considered this particular case before, but because I, as someone who, objects to the third party doctrine and the way it's been used to gather all that data that you're talking about, I wouldn't want to make this argument. I would much rather go back to the days where the government did not have all that information. And in order to get that information, it would have to present you, the subject of investigation, with a warrant. I think that's the proper thing to do, even in today's day and age.
I agree with that. I agree with the fact that I would rather the government have nothing, that the only thing the government has ever gotten is information they've obtained through getting a warrant first, and whatever they haven't, what the government, when I submit my tax return, the only people who are entitled to see that information is the IRS. My tax data should be, the information I provide to get my tax return should only be used for the submission of my tax return, and not for any other purpose. So if there's any information I share with the government that I'm legally obligated to share for a very specific, well-defined function, a task, I'm supposed to have privacy with respect to the sharing that information with the government, and that information is only supposed to be used, for that purposes. It's ironic that they gave all this information to access all these doggy and all these institutions to get all this data. Didn't they just put in jail or something the guy that released Trump's tax returns? I mean, that person went to jail. The person who was responsible.
Okay, that's an interesting
point. So now all our tax returns. Now Elon Musk has my tax return. Okay.
Well, I don't know that Elon Musk has your tax return.
Everyone in doggy. Okay. And who else they're sharing it to, and Palantir, okay, all have my tax return, your tax return, and everybody's tax returns. So, for what purpose? Okay, what do they need to learn about me? Okay, that's going to make government more efficient. Okay, so nothing. Okay, it's just complete bullshit. Okay, now maybe they're populating the AI models with it. And they're not very honest about what they're actually using the information for. And if they're not honest about what they're using the information for, okay, then how can we claim that there's any good faith whatsoever? Okay.
I am definitely
a specific answer and saying we're only using the data for these purposes. Okay. If they can't answer that question, the assumption should be they're acting in bad faith. Okay. And if you look at the information, if you look at the responses they're giving, okay, you'd see that what they claim they're doing with the data, they don't need that data to accomplish that objective. So clearly they're giving a lying answer, which means that they're acting in bad faith. And I think you either have to be really dishonest or a moron to not understand that the information they're collecting has nothing to do with what they claim they need the information for.
I think that there are a ton of people who are outraged by this practice like you are, and a ton of people who are also outraged about the cell phone searches as an exception, application of the border exception. And what we're trying to do right now at Pacific Legal is look into various ways of challenging this. As you know, what we do is we will sue the government fighting on behalf of our clients whose rights have been violated by government when it abuses its power. And that is exactly what we think it's doing in cases like this. I was surprised actually, because a lot of times my interlocutor about the third party doctrine is Oren Kerr, but I've been looking at his book Digital Fourth Amendment, and he's got a whole chapter on the border exception. And he agrees with me on, a bit of different reasoning that they should not apply the border exception to these digital searches at the border, that they should have to provide warrants, because what are they doing? I would say there's one very narrow exception that you would have to talk about, but with one very narrow exception at the border, if they are searching your digital data that's on your devices or on your disks, all they're doing is gathering evidence about you. They are not serving the traditional functions of those searches at the border. So there's no reason to carry on these long-standing doctrines about border searches to this realm. And he would characterize it as sort of restoring equilibrium. There's a balance of power between you and government. I would say it's an application of principles to the context, and you have to do it properly. So we have different methodologies, he and I, but we agree in substance that that is an outrage. And I think he would also agree about this consolidation of the database. There's various angles that you can use to attack that. One of them you sort of implicitly talked about, which is, why is it the case that if I am a good citizen and I'm going to comply with my duty to file a tax return and et cetera, that suddenly I am giving up all of the privacy and any of the data that's contained in that tax return to be consolidated, searched on who knows what pretext and et cetera? Isn't it just like that panopticon that Bentham designed for criminals, right? People talk about the digital panopticon, and they've said, oh, Facebook and et cetera are making the digital panopticon, but no, Trump is making it by executive order. I looked at that order and it's very broadly worded. It's not like they said, oh, for these very narrow purposes, you can search the IRS database to see basically, who is violating XYZ thing. And then you can integrate that information with something else because you're trying to actually find criminals or, as I said, even rule breakers with respect to the tax code or something. But no, they're not even bothering to do that. That executive order is very broadly worded, and many people are reasonably concerned that the government is amassing this giant database and that their Fourth Amendment rights are being violated.
Yeah. What did Ben Franklin say about trading off security
for privacy? Yeah.
Yes. What did he say?
Liberty, right?
Yes.
Yeah.
Right. It was the illusion of security, and we were surrendering liberty in return.
And you end up deserving neither if you're going to make that trade-off. Yes.
Right. So the Constitution was designed to us to preserve our liberty, right? It's not a document. What did you think James Madison designed a police state?
Yeah, right. I don't think so.
So that's pretty much what MAGA is asserting in these executive orders search, is that the Constitution was designed first and foremost as a document to give as much power to the president, and the president to implement a police state, and dole out inalienable rights as now privileges at his discretion on who has the right and who has the privilege, who lacks the privilege. It's been a perversion. Have you looked at all from a privacy perspective of these use of these predator drones and the issue of these predator drones in LA.
This is something else we're interested in. I mean, in some jurisdictions, they're using these drones to enforce zoning codes and stuff like that. And I think in many cases, the use of these drones could also be seen as violating Fourth Amendment interests. So this is another area, that if people believe that their rights are being violated by local government or state, federal government, any level, then they can go to Pacific Legal and see whether there's a viable case there.
Yeah, and yes, this is just really. What are some of the other things you think are the egregious violations that get you? For me, I easily get upset. So,
so another one that we didn't really talk about at all is, I mean, I guess you mentioned it a little bit tangentially with respect to the airlines. My guess is that the airlines are giving it to the government, this information, due to some sort of regulatory requirement. But in some cases, third parties that you do business with are selling information to the government. And that is something that there's even been enough political will behind to pass something in the House. I think it was in the last term. The Fourth Amendment is not for sale, is what I believe that they call it, the act.
Right.
It passed the House and then it never did anything in the Senate. And so right now there's no version of it. I do not believe that government should be able to buy data from these third-party data brokers just like any other customer, because government is not just any other customer. And going back to some earlier points that you made, first of all, our current administration is using what I would call a lot of red meat issues in order to make people more willing to give up some privacy in these areas. They're concerned about some illegal immigrants have come in and, distributed fentanyl, and it resulted, right? Or they've committed crimes and stuff. So they think somehow government, because it's trying to do good and clean up things, that's a good pretense.
Well, let me ask you a question on that point. Okay.
Yeah.
If someone wants to voluntarily surrender their privacy rights, their constitutional inalienable rights, they can make that choice for them. They can't make that choice for me. Okay. So they want to make that choice for me. Okay. So if they want to surrender their information and they don't care about what information people get about them, or the government violating the third party doctrine with respect to them, or buying data from them, that's a choice they make for themselves. They don't have the right to make that choice for me.
I would agree with you, but then it's because I have an analogy that, with respect to another argument I used to make, there were a lot of, big earners who would say, oh, I don't mind paying more taxes because we have so much debt and maybe we'll help pay down the debt, or et cetera. And I actually think even if, a Bill Gates or Warren Buffett or whoever else you could say who's very rich, Elon Musk, even if they said, hey, I'll pay more taxes, et cetera, and just help pay down the debt, I actually think it would be immoral for them to do that in the current situation in which there is no plan to actually cut spending or end the farce, that is our federal government and its spending and its debt and everything else. It's, enabling this drunkard, so to speak.
Right.
And Rand Paul has used similar arguments recently when he has been opposing the big beautiful bill because it gives a $5 trillion raise on the debt ceiling or whatever it is, instead of little tranches of it that might reasonably be necessary while they're, turning this huge behemoth of the federal government around to not be spending into oblivion anymore. He's saying there's a difference in the sort of assistance you would give a government that is really trying to get on the right track versus this huge one-time increase in the debt ceiling. And similarly, I don't know that it's good to tell people, hey, if you want to surrender your privacy to the government, to just get people willingly doing this,
Oh, no,
because
no,
it creates momentum
the
in the
point,
wrong direction,
the
is my
point,
thought.
the
Yeah.
point I'm trying to make is,
Yeah.
if somebody right now thinks it's appropriate government policy because they live in fear, I don't want to encourage anyone to give any information. Okay. I
Okay.
don't want anyone to think I'm fearful of immigrants and this and that and that.
Yeah.
So I'm okay with the government getting this information as a general rule. No, no individual has a right to deprive me of my inalienable rights, or to encourage government to deprive me of my inalienable rights because they're willing to do so. I don't want to encourage them to do so, but what I
Right.
want to make clear, okay, what they do is their business, and I don't want to get into their business. What I want to make clear is then that's another third party doctrine. They speak for themselves. They don't speak for me. People
Yeah.
really ought to, and I'm going to be, you know, I'm going to use words. Sorry, Amy. Would have to. People, when it comes up to my preferences, my rights, what people think I should surrender, should just shut the fuck up. Okay,
Yeah.
because they have no right to speak on my behalf or anyone else's behalf. So if they feel better off surrendering rights as a personal preference, there's a difference between people having their own personal preferences, as people wanting to universalize their preferences into policies that are imposed on other people. Okay, the
Yeah.
Constitution's supposed to protect me from the tyranny of the majority. They're supposed to protect me against a whole group of people, even if it's 99% of the population. Okay, I'm supposed to be protected from the 99% of the population who thinks I should be deprived of my freedom of speech, that they have the right to take that away from me. No, there's
Yeah.
only one way of doing that. If the majority is so big, okay, they can change the Constitution by an amendment. Okay,
Yep.
they can amend the Constitution. Okay, so what people should be doing is, if they don't like the Constitution, don't like inalienable rights, don't like the rights expressed in the Bill of Rights, okay, and think that they're no longer adequate for today's society, okay, they should not expect judges to redo and rewrite the Constitution. They should amend it. And the fact that judges are rewriting and not protecting my rights, okay, they're failing. And I believe they're dishonest. I believe they know they're failing. They're intentionally giving more power to the government. They're giving the benefit of the doubt of the government, okay, and they're not giving the benefit of the doubt of the citizen. And they were supposed to protect the citizen against the government, not to protect the government from tyrannizing the people. Okay, and what
I
the
mean, there, there
is
are
tyrannizing.
individual rulings that I disagree with, but in general, I'm very optimistic, and it is why I am working where I'm working, where I think that we actually can do some good through the court systems still, even today, where sometimes the rulings that you get are disappointing. And in particular, in this realm of privacy, I am cautiously optimistic that we're going to see some good rulings. Like I said, the Fifth Circuit in Smith, where they completely shot down the idea of these geofence warrants out of Google and said, no, they are tantamount to general warrants under the, that the Constitution was supposed to protect us from. Again, I'm very optimistic. So we'll see. Gorsuch and Thomas and others on the court have been very good. If you read the dissents in Carpenter, concurrence in Carpenter, very good stuff. One point I wanted to make: these people who think that the fact that there are issues of safety and that the government is well-meaning, and so when it's trying to do good things for us, we should cut it some slack and give it more power, and et cetera. You have to remember that governments in the course of history have always been the biggest rights violators of human beings. And our founders knew that government, if it wasn't restrained properly with a constitution that delimited its powers, with a system of checks and balances to make sure that those limitations are upheld, that this is strictly necessary, because they saw, as you said, in the past, people would use governments in order to impose the tyranny of the majority, the will of the majority, onto the minority and violate their rights. I don't believe that if a majority of people, a significant majority of people, were able to modify the Constitution and eliminate our First Amendment, for example, that would be a just outcome. But you're right, with the Constitution that we have set up, it would allow for that possibility at least, and that is what they should pursue. What you and I would have to hope, Jeffrey, is that if people were going to try to modify our Constitution, eliminate our First Amendment rights to free speech, eliminate our Fourth Amendment rights to be free of unreasonable searches, that we would have enough time to educate people as to why that's a bad idea to avoid that result.
No, I'm not. I'm not. I want my constitutional protections because I don't want to rely upon other people protecting my rights, and rely upon the intelligence and wisdom of the American public. So, and the founders did not write a document that the way I'm supposed to preserve my rights is to rely upon the goodwill and faith and the intelligence and wisdom of my fellow citizens. So the Constitution was written to preserve my rights as a self-sovereign individual, and that nobody should be able to, what was the original image of the the flag of the U.S. during the Articles of Confederation was the flag that Franklin liked, which was the "Don't tread on me." So, and so basically our government was founded on the principle that our most important fundamental right was our right to be left alone. Okay. And to the extent that we're subject to surveillance, we're clearly not being left alone. Okay.
Let's have that debate another day, Jeffrey, because I've done quite a bit of work on Brandeis, and I actually think for him elevating the right to be left alone makes the protection of our interest in being left alone subjective because it's on a pragmatic foundation. He was a legal pragmatist. Okay. So let's, just kind of cabin that off for another day. But I agree with you that our interest in being left alone needs to be respected, that our Constitution, through the protection of our rights to have our property not taken or searched without proper procedures and et cetera being followed, that's how that interest is protected. But no, we have the same goal. I just have different ways of getting to the protection of those interests.
Yeah, I mean, you have faith in the process. I have zero faith in the process. I don't want to be in jail, so I try. I follow the rules, but try and choose my activities. That subject me to as little involvement, with the government as possible. I would never be in a business that I have to interact regularly with government, that I have to lobby people, look for tax preferences, look for privileges, stuff like that. Try to do businesses that have like very little obligations other than I have to file financial statements, and have to file tax returns. So, that you got to comply with, but outside of that, I try and avoid activities, where I have to knock on the door. And I think people should not engage in activities where they got to go to Washington and look for preferences, because that's what they're looking for. That's the reality is they're looking for preferences. They're looking for preferences. They're looking for privileges. And that's what people pay all the money lobbying doing, is to get those preferences, and privileges. And they pay a lot of money because it works, because there's a return on having access. So, and we can see, the attacks on Harvard and and Columbia, under the guise that, that there's clearly they have no belief in faith in the markets. If I look, I'm Jewish. I got advice to any Jewish student. Okay, if you think Harvard is a hostile environment to Jews, don't go there. Okay.
Yeah, just
If
don't
you
spend
think
the money
Columbia
on their
is
tuition.
hostile
Yes.
to Jewish students, don't go there. Don't go to a
Mhm.
school that you think creates a hostile environment. Don't donate money to a school that you think creates a hostile environment. And I can tell you, if the students stop going, if you choose to go to a school, understanding that that's the environment, stop whining. Okay, you went in there with your eyes open. Accept the consequences of your choice. Stop whining. Okay, I think what I've seen is that MAGA are the biggest snowflakes around. I used to think that it was the leftists and progressives that were the big snowflakes. I think MAGA is the biggest group of snowflakes. They whine, they claim more victimhood than any group of people that probably have suffered significantly more, okay, and have a greater right to claiming victimhood. That I think nobody claims more victimhood than MAGA does, okay, and I think that nobody whines more, than MAGA people. It's just a whining party, okay. It's a party for me of people. If you're a whiner, you're a loser, okay. So I know this is off topic, but that's how I
Yeah,
think. If you're
a
a
bit far
whiner,
afield from our topic
if
today.
you're a
Yes,
whiner,
yes.
you're a loser. Okay. So, so so I don't see the courts doing a really great job at I think the courts have done a decent job, but not a great job at protecting. The courts didn't stop this data grab. Okay, they didn't. The courts have so far allowed the data grab. So I think the courts have allowed a lot of things. Again, they've given the benefit of the doubt to government. Okay, and I think James Madison design was to give the benefit of the doubt to the people, not to the government. Okay, so given the fact that I think that there's clear evidence that the benefit of the doubt was not meant to give government more power and its ability to accumulate more power. It was to be suspicious of the accumulation of power, and the government would have to make a good case on why they needed the more power.
Yeah.
And meanwhile, while the government was doing that, these people's injunctions should have been preserved. The restraining order should be preserved instead of giving the government the benefit of the doubt until they're relying upon the final settlement. And they're basically claiming that there's no damage to the people.
Okay,
But
so I don't have a whole lot of knowledge of the particulars of the Doge cases. One that I was looking at fairly closely was hinged on appointments clause violations, whether Musk had been appointed properly and et cetera. That's an entirely different issue. So the thing that I'm interested in with respect to this database claim is getting before a judge claims having to do with each individual agency exceeding the authority that it has to collect information for a limited purpose if it then turns that information over into some big overarching database. Like I say, it's Bentham's digital panopticon. Clearly there must be some going outside the authority that they were given there, plus of course bringing Fourth Amendment claims. And I haven't seen enough in the way of good Fourth Amendment claims being brought yet, and the fact that they're going to be completely denied. I think we've got to get the right claims before them. Of course, one of the things, like I said, good faith exception has thwarted some people from having justice, even though their rights were violated in the Fourth Amendment context. In other contexts, many contexts, it's an issue of standing, the standing doctrine, the way that works in United States courts, and can be a challenge to getting justice vis-a-vis the government as well. So this is what we're working on at Pacific Legal. We're trying to position the claims in an appropriate way. A lot of times it's very difficult to get preliminary injunctions against government. Just recently, I'll give you an example. I was researching the idea of getting a preliminary injunction against the entity that collects property taxes in the District of Columbia. And there's a longstanding doctrine that says that it's virtually impossible to get a preliminary injunction against the collection and or accumulation of tax debt in the District of Columbia, because there's a priority on the government getting its taxes. Again, they believe it's the government's money, not yours. The government getting its taxes expeditiously. And if you get a preliminary injunction against them, then somehow that's going to interfere with that. And you would need to show that virtually, under no circumstance would you lose the particular lawsuit that you're, suing under, the theory that you have it on your side. And second, that there wouldn't be any harm, or, there would be significant harm if you only got your legal remedy, which would mean that later you would get a refund of your taxes or whatever. So there's just, when they use these pretexts of taxes or other reasons like, protecting our security, there are rules in place that make it very difficult to challenge. And so what you have to do is you have to try to frame the strongest case that you possibly can, taking into consideration rules like standing in good faith and this presumption that the collection of taxes somehow entitles the government to extra powers.
Yes. Why should there be a presumption of good faith on the part of the government and not good faith on the part of the citizen? I think there was given the disparate power. The fact is that the citizen can't coerce anything on the government, and the government has coercive power over the citizen. And I think the people who wrote, I think James Madison understood that. Maybe Donald Trump doesn't understand it. Okay, but maybe Tom, and I don't believe Gorsuch and Olita and Thomas understand it, because they're looking to justify any power Trump wants to have. They want to give to him. And
I don't believe that exactly. Otherwise, I wouldn't be in the business that I'm in.
The immunity proved that. My point. Nowhere, the immunity was clearly discussed at the Constitutional Convention and rejected. Okay, there was no presidential immunity. Show me in the Constitution where there was, and don't think that they didn't understand it. It was discussed at the Constitutional Convention. Should the president have immunity? Okay, and they decided no, it's not in the document. It was made up. They made that up. They made it up. Okay, they couldn't cite anything in the Constitution. All these people claim, I want limited government. There's no way you can have limited government with a president who's above the law. Okay, no way. Okay, they're full of shit. Okay, you have an imperial president with more power than the King of England. Okay, than King George. You can't say you believe in limited government and that you believe in public meaning originalism. Okay, and you support that. Also, in the case regarding Colorado, okay, Alexander Hamilton, okay, remember him? Okay, he wrote one of the Federalist Papers, right? Okay, in Federalist number 69, what did he describe the president? Okay, the president was an officer of the United States. Hamilton said that the president is an officer of the United States. Is that, you think that's clear? Is it ambiguous? Okay, and they're having a debate. Is the president over an officer of the United States? And they determined the president is not an officer, so not subject to that insurrection clause. So they can't remove him from the ballot. Okay, you think they never read the Federalist Papers? So that's stupid. If they're looking to what the intenders of the founders were at that point in time, read Federalist 69. Very clear. Alexander Hamilton. Okay, so writing in defense.
There was, as far as I understand, a lot of controversy around that as well. But this is far afield.
I understand this controversy, but the only place it's referenced in the Federalist Papers, okay, in the document meant to explain to the American public the role of the president. That was the role of that document. We're trying to get the Constitution approved. Okay, they're trying to get it ratified. They're writing documents to explain to the people why they should ratify the Constitution. And in the document that they're trying to define, the people who were at the Constitutional Convention, okay, at the convention, writing the document, okay, they then are telling the people, this is what it says. I know there can be controversy around it, okay? There can't be controversy about the authority of Alexander Hamilton's words. Now, if somebody 100 years later said different words, okay, yes, there might be controversy, but if you're a public meaning originalist and you're looking at the words and their meaning at the time they were written, okay, who's a better authority? There's no other word than Hamilton's word, okay? The president was described as an officer of the United States. In the document, explaining to the American people the role of the president, okay? To get them to vote on behalf of, to ratify the Constitution, okay? What source could be more of authority than that? Okay, so I understand all the bullshit that people say about.
You think there's a conflict between someone like Thomas holding himself out as a public meaning originalist and not taking that as dispositive with respect to that issue?
Thomas is full of shit, okay? Alito full of shit. Gorsuch full of shit, okay? They adopt that philosophy when it produces the outcome they like, and when it doesn't produce the outcome they like, they choose some other words because they're clever with words. So they're full of shit, okay? They don't believe in public meaning originalism. They apply it when it gets to the outcome they want. All they want
So,
to do is to generate the outcome they want, and then they use the words to justify
so
the outcome they want.
obviously, I disagree, because otherwise I wouldn't keep doing the job that I'm doing day in and day out, which I love, which is to actually fight through the courts and hopefully get before those justices and convince them that we have a case, and that, we are right in what we're asking them to rule on. This is what I'm doing all day at Pacific Legal. My question for you then is, if you can't achieve justice that way, in what way can you?
Oh, I think the question is what do you do and what should you expect? Should I've made my living as an investor. Okay, so I got to see the world as it is. I can't see the world as I want it to be. I can't see the world as I imagine it to be. I got to see the world as it is. If I don't see the world as it is, okay, I'm a lousy investor and I will lose all my money. Okay, I'm not a lousy investor. I'm a great investor. Okay, so I'm a great investor because I'm very good at seeing the world the way it is. Okay, that doesn't mean you don't keep trying to change it. Okay, obviously I'm committed to trying to change it because I bankrolled Gab, I bankrolled Parler, I'm bankrolling BitChute. Okay, I'm bankrolling the parallel economy. So I'm fighting what I think is, like you are. I think I'm fighting the good fight because I think it's worth fighting. But that doesn't mean I'm fighting it thinking I will win. I'm fighting it because I want to fight it because I think it's the right thing to do. It doesn't mean that I think I will win. I'll do my best to win, and I think it's worth a fight. I mean, I think in the I like the movie Mr. Smith Goes to Washington. I mean, I'm an idealist in my own way, and and when Jimmy Stewart is up there and he's giving his filibuster, on the kids' playground or whatever it was, and then he goes to his idol, the senior senator from his state, and he said, you used to believe that lost causes are the causes most worth fighting for. So I think maybe you and I, you think you're not fighting lost causes, and I hope you're right. Okay, for me, I don't mind fighting a lost cause. Okay, if I think it's a good cause, even if it's a lost cause, it's worth fighting. Okay, because that's how I define me. Okay, I define me by fighting for things I believe in. Okay, I don't have to think I'm going to win. I just have to think the cause is worth fighting for, even if it's a lost cause. I'm going to fight for it. And who knows? Maybe I'll win. So I don't have the expectation I'll win. I have the hope and aspiration, and a win. But that's why I view the investment as somewhat different than other things I invest in. Where I'm just looking for financial gain. But if I invested only in lost causes, I'd go broke. I have to be a realist. So my sense, from what you're doing, I think I would encourage people to contact you. And that you would fight hard. That I don't think there are many people that would fight as hard as you for issues on principle with respect to privacy preserving and wanting to hold the government accountable. And I would hope people would contact you and that they would think it's a fight, even if it's a lost cause, it's still worth the fight. So I think the things you're fighting for, are worth fighting for. Do I trust? The people that you're fighting in front of, and do I trust that they're honest, honorable, well-meaning people who want to live consistent with the founding principles of our country? No, I don't. Okay, I think they're all full of shit, trying to justify shaping society in the image they want society shaped, and I don't think they care about the Constitution whatsoever. I don't think anyone on any court cares about the Constitution. None of them. Okay, I don't think anyone, look, how embarrassing is it? Okay, you have Kristi Noem, okay, gets asked a question about the Constitution. What's her answer? I have no clue. Okay, yesterday they asked Pete Hegseth a question, and he also said, I have no clue. Okay, we got people responsible in law enforcement responsibility who don't even know the law. Okay,
Well, that's different from judges, though.
I think it's all. I think the judges don't care. Okay, I don't think they care. That's my belief. Okay, and I think I have a lot of evidence substantiating that belief. I think there are some cases that you sit back and say, "Oh, gee, in this case they did." Yeah, I think they did in those cases because they like the outcome, not because So I think they justify whatever outcome they want to, and I don't think they ever ever justify rules where they don't like the outcome. They always figure out a way, whatever outcome they want to create, they create that outcome because that's the outcome they want. And then they're very good at wordsmiths. So they're very good at coming up with the type of words, that justify their conclusions. So, do I think you get justice in front of the courts? No, you get the law, but you don't get justice. So I don't dispute that you get the law. Do I think the law is just? No, I don't. Do I think I think, that they shouldn't call the DOJ the Department of Justice, because it's unjust. So they could come up with some other name, the Department of us having the right to persecute who we want to persecute. Okay, that would be a more accurate name. Okay, than the Department of Justice. So but we don't really care about truth and labeling because the truth is something not found in Washington D.C. It's like they say if you want a friend in Washington, get a dog. If you want a truth in Washington, get a dog. So that's my expectation. But that doesn't mean I don't encourage. That doesn't mean I think that the work you're doing is unimportant, because I think the judges. I don't think are guided by the Constitution. I think they're guided by their own values and personal principles. I don't think they're guided at all by the Constitution at all. So I think they also be impeached on the basis of they all swore an oath in office that they don't believe in. Well, except for Trump, he's the only one who was at least honest enough to say he signed an oath that he's not subject to. So, he said he doesn't think he has to uphold the Constitution, even though that's the oath he took. At least he's honest about the fact that he signed an oath that he doesn't think he's bound by. So other people make claims that they're bound, that they're actually, following the oaths that they signed. I think none of them follow the oaths. I don't think any of them even have the intention of following their oaths. And I would impeach all of them. So every single one of them. So all of them. I'd impeach every judge. Everyone who is impeachable, I would impeach every single one of them, independent of their party.
And would that impeachment be constitutional, Jeffrey?
In my opinion, yes, because I think they've all violated
right?
I think they've all violated because they swore an oath to office that they didn't believe. Okay,
Impeach
every one of
them because Jeffrey thinks they don't.
I think a case could be made how they made an oath and how they violated their oath of office. So I think a case could be made how every one of them has violated their oath of office. Okay, so I think if you put them onto a court, okay, and got a Athenian type of style where the community got in and you could have a skilled prosecutor show their record of where they really did not judge according to the way they claimed they would judge. When they went to the hearings and they testified about what they believed their judicial philosophy is and what their beliefs were, and then all the things they tried to say about, well, these are all hypotheticals and stuff like that. If then you bring the body of evidence, that they really all lied at these hearings. Yes, I think they would. They would all. I think a strong enough case could be made. That all of them could be impeached. Yes, I sincerely believe that. Okay, so.
Well,
I sincerely believe.
I don't believe it, and I'm glad that just because of disagreements with rulings in judicial philosophy, that you cannot just impeach justices for that, because I don't think that would. We do need the system of checks and balances, but I do think that they're an effective check.
I'm not impeaching them for their judicial philosophy. I want to impeach them because they make a claim to having a judicial philosophy, and they falsely represented the claim that they really believed that philosophy that they did. So
that's a different topic we could discuss as well, because you're talking about this public meaning originalism, and in fact, what I would adhere to is something more like what Tara Smith is talking about in her book, Subjective Adjudication, where she calls into question any form of originalism as, in effect, going towards positivism or pragmatism at the extremes. And that's probably what you're getting at when you disagree with these justices' rulings, is that it happens to be the case that you cannot have an objective result in certain applications, at least, of
Well,
the originalist method. Yeah.
if they're going to be applied that, then they should say, this is my judicial philosophy. I'm not bound by the Constitution. I'm bound by my subjective.
But they don't believe that, Jeffrey. They don't believe that. And I actually do think that they're acting honestly within what they believe their judicial philosophy to be. Sometimes we might disagree with what they say.
They all
but,
claim
yeah.
to be public meaning originalists. So just tell me where in the Constitution did they come up with the immunity for the president? Where they come up with that? Where?
Yeah, I mean, no, and we could have that discussion another day, but it's beyond the scope of what I was prepared to discuss with you today, Jeffrey.
It's nowhere in the Constitution. It was addressed. It's not in the document. The founders were clear. It was not in the document.
Well, the Federalist wasn't in the Constitution either. So anyway.
What do you mean the Federalist is not in the Constitution?
I mean, not every word of the Federalist is in the Constitution either. So you can't.
The Federalist was not a document of the Constitution. The Federalist was the people who wrote the Constitution.
I know. But the people who wrote the Constitution were all different human beings themselves with different political philosophies and ideas about what the exact proper system of checks and balances should be, right?
The document doesn't sit back and say we have disagreements, and so whatever words we have are completely irrelevant. Some people here
not that the words are irrelevant.
Some people might have believed. Some people might have believed.
Again, it's some people might have believed that the words on the page at the end that need to be upheld. But this is another topic for another day, Jeffrey.
Yeah, you only know the words that they agreed to. Those are the words they signed, right?
Yes.
Those are the words they agreed to. Okay. And they wrote their words, limited and enumerated rights. Okay, and whatever was left to the states and the people. Okay, so anything that's not
what
there,
we're trying to hold them to. Yes.
Exactly. Everything that's not there is to be deferred then to the states and the people. Anything that's not explicitly there.
Okay, but we'll have to have this conversation another day if you want to talk about presidential immunity, because it's certainly not my area of specialization, Jeffrey.
Doesn't have to be. Anyone could just read the document and say it doesn't appear. Okay.
I actually think for me to be prepared to give you a good answer on this question, that I would have to go do a bit of research on it. And that's definitely one of the things that I've been learning with my time at Pacific Legal, that there are, certain topics that you have to really dig in before you can decide that a Gorsuch or a Thomas is somehow dishonest. There's a lot of things that they have said that I very much think is good, but I might disagree with them on some things as well. I would need to dig in more.
I'm sure people could find a lot of things that Adolf Hitler said that people could agree upon.
Oh gosh, no, I don't care. I don't care if Adolf Hitler once said the sky is blue. No. We're done.
I think you can find a lot of evil people who have said certain things that people.
Okay, so Jeffrey, I'm going to have to go if you're going to start talking about Supreme Court justices as evil people. No, sorry, I don't agree.
You're entitled to
not any of them, not even the ones that I disagree with even more. No, sorry.
No, I think. Well, I'll ask you to consider this as something that I'd ask you to find. The question is, and this is not for you to answer right now. I'm just asking you to think about. The question is, do you think that the presidential immunity is a trivial issue? Okay. Do you think the founders thought the presidential immunity was a trivial issue? And if you think it's a non-trivial issue, okay, and clearly the MAGA world thinks it's a non-trivial issue, okay. The argument they basically made was a president can't function if not subject to that immunity, okay. So that's an opinion, okay. That's an opinion, so if it's a non-trivial issue, and you have a bunch of people who claim that they believe in public meaning originalism, as the people you cited claim to have that belief system. They don't claim to be disciples of Tara Smith, in her work, and I've read Tara Smith's book, and I find a lot of it appealing to me. But these people got up, they testified, and they said they were guided by the text, that they're textualists. Okay, they're public meaning textualists of the Constitution. They read the text and try and figure out what the meaning of the text was at the time the text was written. That's what they all have more or less
But
claimed.
not just anyway.
So
So
all I'm asking you on this issue, okay, study it up a little bit if you want to, and then if you think, that if you think you think they acted in good faith towards that principle, okay, even read their own opinion where they don't even cite the Constitution text, okay, to come up with their rationale that basically their rationale is basically, anytime you want to impeach the president, whatever you want to use against them on a criminal court, you have to come to us first, and we'll tell you what's admissible and not admissible. I mean, that was basically what they came up with. So if you think that's what James Madison designed, read up and tell me you think that's consistent with James Madison's design, of the Constitution, because the Constitution is James Madison's design. Okay, that's why he's known as the father of the Constitution. Okay, like the Declaration was a lot of people signed that Declaration of Independence, but there was basically one author, Thomas Jefferson. Of course, it was discussed, edits were made, but we know the Declaration is Thomas Jefferson's document. We know the Constitution and the Bill of Rights is James Madison's document. So for people would have to then go back and say, what do you think James Madison meant about, the issue of, presidential immunity, and then tell me that you believe they came up with a good faith decision. If this is if you want to take this challenge, or you could just say it's not important to you, and that's equally okay. So,
I'm definitely buried in plenty of legal research on Fourth Amendment issues at the moment. So,
okay, so
if it does become relevant to a case that I'm involved in, trying to protect Fourth Amendment interests for our clients, there's a chance that I might be digging into that research. But at this particular moment, it hasn't come up.
Okay.
I mean, certainly, challenging President Trump's authority to amass data into a vast database by executive order is something that I'm interested in. So if I need to bump up against it to do that, I may indeed have reason to go look into these issues.
Okay, so how can people? What type of issues should people bring to PLF? Why don't you tell briefly? So rather than
so PLF has.
Why don't you plug yourself in PLF now?
Sure. So PLF has a number of practice areas. We have separation of powers. Whenever the government is acting outside of its authority, or a particular action of government is something that should be done by another branch of government, or maybe even state government, and they're usurping the authority. Violations of checks and balances, acting in excess of authority. If your rights are violated, then it's a separation of powers case. We have equality and opportunity, in which we are often looking at ways in which government discriminates against people because of inherent characteristics like race, sex, sexual orientation, etc. If your rights are being violated by a government entity, we sue governments in order to vindicate your rights. In those types of cases, property is the longest standing practice, property rights practice at Pacific Legal. And we started in California fighting entities like the California Coastal Commission when it was telling people what they could do with their property, or putting unreasonable conditions on their ability to do what they want with the property that they own. We are now actually sort of separating the property and looking at ways to focus more on environmental issues in a certain part of our practice. So if government entities on grounds of protecting the environment are violating your rights to your property, that's something that Pacific Legal will handle, and is handling in an increasingly specialized way. And then property rights generally, and it's the Fourth Amendment practice comes under property rights, because again, as I was talking about earlier, I believe that the right to privacy and the way that it's protected vis-a-vis government is by the Fourth Amendment, that the way that could be done objectively is through our rights to property, the associated right to contract, in some cases, the right to liberty, that those rights are going to be vindicated for people through PLF, through our property rights practice, of which I'm a member. So go to pacificlegal.org. Pacificlegal.org is where you can find out what we do. And there is a form there where it's a case intake form, and you can type up what is going on in your particular situation, how you believe the government has violated your rights with respect to these various interests that I've talked about in our various practice areas, and we'll contact you. And if you say specifically that it's Fourth Amendment and that you saw me on this show and you're interested in having us help to vindicate your rights with respect to some of the examples that we talked about earlier in this show, I'd love to hear from you. And Jeffrey, I'll send you that link, the specific link where people can fill out the form.
Okay, great. How can people contact you directly?
So you can find me on X, right, at Amy Peikoff. I'm there. And otherwise, I've got a website at don'tletitgo.com. But as I said, through Pacific Legal, if you fill out the form and you ask specifically that that it gets referred to me, that it's going to be.
Well, I like the fact that you define your area under property, because I will remind everyone who's watching a quote of James Madison, probably a quote unfamiliar to Thomas and Gorsuch and Alito, since I don't know if they've actually read any of these documents. I don't even know if they know who James Madison is. But James Madison said we have rights in our property and property in our rights. So all our inalienable rights are part of our property. They're as much as our physical property. They're part of our property, and they're inviolate, and they're inalienable, and they cannot be separated from us. So any violation of our rights is a violation of our property, because we own it. Okay, we own our rights. Every individual owns their rights, and those rights cannot be taken from them. I think that was a very succinct expression of James Madison's part. I think it's clear about what his intention is, about what he means by that. So I like the fact that that's how PLF treats it. And I hope that every American remembers that. So, Amy, I always give the last word to my guest. So go ahead, take your last. So you have the last word.
Okay, so thanks for having me on and allowing me to talk about the issues that I care about. And as I've seen, Jeffrey, you are not a person who holds back with respect to his opinion. So that's something that we can always count on you for. Maybe some of these areas that we've sparred on we'll talk about in another day.
Well, whenever you want to come back and you want to talk about something, you know who I am, so you've dealt with me for enough years
that you won't hold back. That I
know. So yes, I never hold back. I'm authentic. So what you see is what you get, and you have a open invitation to come back anytime to talk about whatever it is you want to talk about.
Sounds good, Jeffrey. Thank you.
Okay. Well, good luck on all these cases. So I hope you.
Yeah, and as I said, some of these cases depend on us finding plaintiffs. So if you see yourself as a potential plaintiff who wants to fight, for these principles and to protect your rights, pacificlegal.org.
I know I told Amy to give the last word, but I just want to reinforce her statement. Okay, if you think your rights have been violated and you feel impotent, okay, don't feel impotent. Feel empowered. And organizations like PLF and Amy are there to help you. And from my reasonably long experience with Amy, I know Amy will diligently, vigilantly fight to defend your rights. I mean, Amy might trust the system more than I do, but that doesn't mean that she will not put as much effort to fighting on behalf of you, as I would. So I will vouch that Amy will be a very good agent on your behalf, to fight for these principles. So please, no one out there feel like a victim. Okay. So, if you think there's been any violation of your rights, please contact Amy, please contact the PLF. And, you might find that, there's a way to defend what you believe is the injustice that has been committed against you, and don't feel powerless. Okay.
Yep.
So thank you very much, Amy.
Thanks very much.
Bye.